Welcome to the channel, ladies and gentlemen. Today we're going to be talking about here something that I have noticed. Now, first of all, disclaimer: I'm not a body language person or anything like that. Expect or anything. There are people who are doing that, but this is just something that you can pick up while you are watching a video or while we're watching a live. The way a person is doing things, the way he's moving, the way you can pick up certain things. Now, I've got two things here. I've got a judge and I've got a lawyer that is speaking to the judge. The judge is trying to make a point to him that I can't do 1, 2, 3 because of 1, 2, 3. He's trying to explain to him, but the lawyer doesn't budge. Okay, now he's looking at him. He's like, you don't understand what I'm trying to say here. And there is somewhere where he's going to actually say, now you are trying to make us look as if we don't know what we are doing, But anyway, let's get into it. Then I will pause there and there, but not too much because I respect you guys, Let's get into it so that we can see what I'm talking about. Let's begin.
In the case of this division, in the case of Mukesi, if I'll give the lordship the reference, in the case of Mukesi of this division, reference.
Now, you see when you are doing something on television in front of people, the whole world or whatever it is, because this is a high profile case. Now, you are talking about a case that was done somewhere far away, right? Now you have it in your computer, but you don't have it in your mind. Now you are starting to quote it, but then you realize that I don't remember very well. Let me just let's take it, guys. I'm not judging. Please don't look at me and be like he's judging. No. Please, let's go.
Mukesi and others versus S. 2022.
Yeah, you see.
I just complete the reference number.
Look at best.
Yes,
I can do better, man.
Where the accused. It's Mukesi and others versus S, case number 45/2021. Is the authority of this division. The accused person left the criminal court to a civil court. Exactly what your lordship is suggesting. To assert.
Listen to that. Listen. Now, when you are hearing something like that, I don't know if the guy can hear, but when you hear a person that you are talking to playing with a pen, you must know one thing. He is not interested because the point he made, he has decided in his mind. He's just allowing you to go and talk because it's your right and everything. But I don't think he's interested for the fact that he's playing with his pen. You will even see when the time goes on. What are you talking about?
Exactly what the accused in this court is asserting. Section 35 right of the Constitution.
Is your client asserting a Section 35 right? On your paper, sir. You see, that's why I say maybe you should file your reply. And then we deal with the matter. When the matter is ripe, you can then argue all these things that you want to argue. The judge assigned to the case will then deal with it. You see, what you are asserting in this case is there has been a cascade of failures by everybody concerned, from the police who keep the accused to members of EST, I don't know what that acronym stands for, to the National Commissioner of Correctional Services, in the way he is kept, the way he is transported, what he eats, who must prepare his food. Now, I don't see Section 35 dealing with those issues. The closest that you come to Section 35 rights is under Section 35(3)(e). When it comes to him being present during his trial.
I want
Now,
you to look
but
at Bester.
the fact that the chef that prepares his food must write his name and surname down before giving him food, is that a Section 35 right, sir?
With utmost respect, that was implication of this.
No, but the thing is, you are saying all your prayers are...
You see, the body language of Bester, you can see that is like, you know, my lawyer, I know you are trying to make it like sound good, but I can do better. Let me just raise my hand because I want to bring a point here which you are not bringing to the judge. You know, he can see what he should be saying, but he's not saying it, you know, because it's now between the lawyer and the judge, and he's fuming. He's like, I want to say something here because I want to put something, I want to put some points because I know where he should be going. I know where he should be going, but he's not going there. Can I just come in there? You know, so even the lawyer, you know, he's listening, and I think the way maybe he put it, it may not be the way that he should have put it. All right. I'm just thinking, remember, I'm not judging. I'm just looking at how the interaction, okay? Maybe he now realized that, ish, and I cannot go back and, you know, put it in another way because it will seem as if like I am incompetent, not incompetent, but I don't know. But I was not wrong. Guys, you must understand one thing. When you are a lawyer standing there, unless you want to be a bigger man, or maybe you know how to be a bigger man, when you are a lawyer standing there, there is a judge there, and you are arguing with the judge about a point, okay? And if you realize that you have made it, the point that you have made it, it's not the way, you know, you were supposed to put it. Now, if you are going to be afraid of saying, okay, judge, let me put this thing this way then, so that you can understand. If maybe you've got another option that maybe can be put down so that the judge can understand. Just like I think I've seen Mpofu would actually do that when he makes a point and then maybe the judges are not understanding, and then he will say, okay, let me put this thing in this way, all right? And then maybe sometimes, I don't know, but sometimes maybe they do get him, but at least have an option on the side on, if they don't get this part, this part, let me bring this one, maybe, you know, they will understand. Just like you see, Bester now is raising his hand, and he's raising his hand because he wants to say something that I think the lawyer doesn't, he's not getting where he wants him to go.
All
anyway,
in terms of Section 35 rights. But I'm saying to you, you go you stray far beyond Section 35. And the case law that you are referring me to does not help you, one. Two, if you want to argue an accused fair trial rights, the criminal court is the place to do so. But now you
know, guys, one thing that you must know, when a person has decided that this is what it's supposed to happen, or this is what I'm saying, and I have made up my mind, trust me, you won't win. Trust me, you won't win. And if that person has power, he's going just to say, listen, this is what I'm deciding, this is how it's going to go. That's it. Because if they have made up their minds, trust me, you can say whatever you want to say, all right? You will never change their mind, okay? You can see even the judge when he's arguing, he's sitting at a point where he thought that the lawyer will understand, because he says to him, listen, my guy, I do understand you, what you are saying, but I'm saying to you, whatever that you want to do, you shouldn't be doing it here. You know, you should be doing it somewhere, somehow. All right? I'm just saying, guys, that, you know, sometimes when you look at people, you might even say, you know what, listen, you know, let me just go with whatever he says and do. But obviously, it's a court, so it's up to them what they do. I'm just analyzing. I don't know if I'm allowed to say that, but I'm just looking at the video and checking things. Okay, guys? Okay, guys?
way beyond that in this application, you see. And that is the simple point in this matter. If you reply and you consider your cause of action properly, you can then approach the judge who will be dealing with the matter and argue all these issues that you want to argue. The judge will then make a ruling at that stage. I am not going to make a ruling in this matter on a half-baked case at this stage, Mr. Moila. That is how simple it is. The case is just not ripe for me to make a ruling, even on this point. That's how simple it is.
If your Lordship could exercise some level of patience for me to make a point.
Make it.
At least to make a point. Then your Lordship can then have this comment after I've made a point, because we've reached a situation where now it's one-sided. I can't make a point.
Make your point.
And proceed.
Now I want you to look at the judge. Okay? They are going to show you look at it.
They don't say. The other things, when you deal with the constitutional rights, the fact that you have a fair trial does not mean that the same conduct cannot violate your right to dignity. Does not mean that it can violate other rights. That is the interrelatedness of the violation of the right. So your Lordship, what your Lordship does goes to the tail end of our application and focus on other minutiae of the rights and ignore the causa. When your Lordship will read our papers, we start, and this is what we say in paragraph 10 of the application. We say, I'm going to read it, because now what your Lordship is trying to do is create a situation as if like we don't know what we are doing and we are informed.
Oh, you see when you are looking at the judge and you say that, already you have messed up, bro. Because when he looks at you, he's like, okay, you think that I'm undermining you. You think that I think you are not do. You don't know what you are. Like already, it's out already. Oh, I hope it didn't say that. I'm just hoping. Because remember, you are trying to convince this guy that is in front of you. So you can't say, now we see that we see that you're trying to make us look as if we don't know what we're doing. You don't say that, guys. You are trying to convince this person. You can't be like being. Anyway,
so it's very important to also place validation here. Paragraph 10 of our paragraph, this is what it says. The ground norm or the fundamental basis of the application is section 35.
This is what it says.
2B, 2E, 3D, 3E, 3H of the Constitution. Right? I'm advised that the observance of this, and when you look at this on this provision, they deal with the speedy trial, they deal with the right of consultation, they deal with the right of legal representation that is effective. And we know when you determine the issue of jurisdiction, you look at the pleadings, the founding papers, what they say, and that's a principle in Kawa. You don't even look at the merits, so you don't even have to wait for the reply, because the founding papers tells you the right that the accused is asserting. The reply, it can't even make the case in the reply. He has made it in the founding papers, and it tells you that it's section 35. It goes on to say that I'm advised that the...
Did you see that? He rolled his eyes. He's like, my guy, I'm done with this thing. Why you keep on saying the same thing always? I've decided, bro. What is wrong with you? Now from here, he's not going to listen even. I don't think he's even hearing him, you know? You will see that already starting to touch some things on the table, and then he's like, listen, my guy, I'm not going to listen to you. Just keep on talking because you want to finish, right? Because I've given you a chance to finish your point, but still, whatever you're trying to tell me, I still don't agree.
Observance of the provision in section 35 of the Constitution highlighted in the preceding paragraph would guarantee my right to a fair trial. Then this is what then we have to concentrate on what I call a tail end of what we are arguing now. In section 35 of the Constitution, I employ this court to adopt an intersectional analysis of other constitutional rights. Then your Lordship speak about the food and all that. That is the intersectional analysis. You can't look at one.
You see, when a person does that, you must know, guys. I don't know, guys, but I think sometimes as people who speak to people, you know, whatever, you have to be able to read the language, you know, the body language. I know we're not experts, but you can see certain things, you know. And when a person looks down and scratches his head, it's like, my guy, you are wasting time here, you know. And also, I think that the lawyer, I don't know how you will do that, I think, but you should be now thinking of saying, which angle can I come from now so that I can try and convince him? And maybe you can say and stop there and say, okay, judge, or whatever they call them, your honor, your whatever. Let me put this thing in this way very shortly. Okay, that is if you've got an option. If you don't, then it becomes a problem because you are going to repeat the same thing until then the judge or your honor is actually angry, which I think is already angry because you are repeating
isolation. So these papers, as they stand, they assert no any other right. They assert Section 35. The fact that he's complaining about the right to dignity does not remove the jurisdiction of this court. That's what it says. And that's the principle of the National Court in Zao. You look at, in fact, what you must really do, you must accept that this version is true for the purpose of jurisdiction, even if he can lose on the merits. And that is important. So it's unfair for the accused person who comes to court to assert Section 35 and is told because now he has raised the issue of torture.
He's like,
they don't dispute that. They simply say that they are allowed to torture him in terms of the Correctional Service Act. The torture is not disputed. It's not disputed that he's incarcerated for 23 hours a day and only given 1 hour of exercise. They simply say that the act in terms of the Correctional Service Act. I can't, as a practitioner, remain supine when I see those violations, because ultimately, and this will then be argued in due course, ultimately and cumulatively, this would affect his mental health. So by the 10th of Feb, you might not have accused number 7 mentally fit. And that's what the case law says. So it's very important that we contextualize this case and not concentrate on the minutiae of other rights.
Are you done?
Yes. That is the point that I was making. So it's clear that the papers say the opposite of what the Lordship is saying.
Are you?
You see now. He's asking him, are you done? Yes, I'm done. But then he continues to talk. Okay? Now you must understand, guys, that when dealing with people, there are people who think about things in a certain way. Now, if you are like you've got a patient person, you know, they will let you go and talk. But there are people that will ask you, are you done? And then you say yes, and then you continue. They get irritated, some of the people. And then you will even see the reaction, you know. And also it will irritate them more and make them more angry, which I also don't agree, because obviously you will say to me in the comments, yeah, but he shouldn't be angry, he should be fit, you know, to take everything that comes to him. I do understand that. Remember, they are human beings. Okay, I'm not defending anybody, but I'm just saying they are human beings. They will get angry. They will, you know, say things that maybe later regret and maybe later apologize for whatever. But all I'm saying is, when he says to him, listen, my guy, are you done? And he's like, yes, and then he continues. Because when you ask a person and say you are done, you expect them to keep quiet, right? But it continues.
And all this subsection. The issue of him being here is the 158 of the Criminal Procedure Act that says every criminal proceedings, he must be here. He's entitled. I don't have to motivate that what papers that is served. That's a legislative entitlement. And there's a plethora of cases to that effect as well. And the reason why I wanted to start with Mukesi, because I thought maybe to prevent some elevation because it's a decision of this division. But there are cases specifically that says that it matters not. Because last week, what you were told that this is
it's not only
we use a notice of application or notice of motion. A plethora of cases that have prosecuted the application through a notice of motion. In fact, it's even encouraged. It's even encouraged so that it can facilitate the proceedings. The reason you see the respondent being here is because they were invited properly and they came here in terms of the invitation. Otherwise, if we adopted a process where we don't know what we are doing, we would not be having a respondent. So that's important for me to place it in a context. And that's why I say that in the setting of the matter down, the issue of jurisdiction would be determined by the criminal. We're in the criminal court. It can't be taken to a motion court or a motion court to determine it. It's this particular court that must even determine its own jurisdiction. If we are wrong on that aspect, then the court will chase us and will gladly leave, knowing very well that we are living, but on the wrong side, we are living with the right side of the law. Because all other cases support our proposition. Then we can.
And I think the judge was actually fair, because he let him keep on talking. Usually, I've seen in the constitutional court, when I'm watching, usually you will find that if a lawyer is saying something and then maybe later, or maybe they keep on talking about the same thing, usually they will stop you and say, you don't have to repeat that, we've heard it, okay, just give us 1, 2, 3, but he's letting him speak because I guess he's trying to respect him, make sure that he says everything that he wants to say, but you can see that he's getting irritated because he's repeating the same thing again and again.
Assist the accused to prosecute someone. But truly speaking, and with utmost respect, it is unfair to select certain paragraphs in the affidavit and we elevate it and we say that this application is about that. When the applicant himself says that the entire application is about this aspect, the rest of the aspects, he's inviting the court to adopt an intersectional analysis, which is not a foreign concept in our constitutional dispensation. I will not take this argument further than that, but I just wanted to place it in context. It will be argued in the fullness of time, but that fullness of time must happen in a criminal court so that we can ventilate it properly and do not be subjected to the strictures of motion court.
Are you done?
Yes, that is my permission.
Mr. Snellenberg?
Let me make this clear. I don't know on what basis my learned colleague just made a statement that the state admitted filtering is Mr. Wester. Take exception to that. Secondly, the application that was brought on motion, Mr. Wester has testified on oath today, and he will do so again in replying affidavit. So why he needs to be present when the motion is moved, I do not know. They selected to bring interlocutory applications later. But the issue of jurisdiction can be dealt with when the matter is fully ventilated. We were not told that we were going to argue jurisdiction today. We were not prepared to do so. And there is no need. This is a pre-trial court at this stage, during a criminal pre-trial. So all these issues that my little colleague has raised, have been raised before whatever forum that matter is in place. And we can debate it, and the court can decide and make a ruling. That is, we follow the pragmatic approach model because we feel matters such as this that doesn't assist anybody to waste time on technicalities. And lastly, we admitted that the High Court has jurisdiction. So we mustn't twist and read out of context. We're going to have serious problems with each other if we start reading.
Yes, thank you, Mr. Snellenberg. Any reply to what Mr. Snellenberg has said?
Just one point, the jurisdiction, paragraph 59 of the answering affidavit. When we raise the issue that this court has jurisdiction, it reads as follows: when we accept that this court has jurisdiction. While the respondent, they say they don't take any, while the respondent do not take the issue of the jurisdiction of this court to determine the applicant's complaint, it is important to highlight that the Act and the regulation make provision for complaint as a request procedure to address inmate grievances. So now they don't dispute the jurisdiction of the court. They simply speak about the other process that needs to be followed. So they can't come here and all of a sudden be opportunistic and then say that we did not say anything about the jurisdiction when they said in their answer that is but in respect of other submission that we take no issues. We are willing to argue this case at appropriate time when the pleadings are closed, but it must be clear that in the criminal court.
So why did you now argue all along if you are now saying this matter will be argued in the fullness of time when the pleadings are closed? Because that is what I've been trying to impress upon you from the beginning, from the first time that you stood up to try and argue this matter. Because even on your own argument, sir, on your own argument, firstly, I told you the last time around, if anything, these papers before me are not proper. At the time, these papers were not served properly on all the respondents. 1. 2. No days were mentioned to them as to when they should answer to your papers. 3. The people that you have cited. I mean, the state. It's the first time that I see the state is cited as an entity. Then, because there are certain members of the executive who are responsible for certain state actions. Then, sir.
Okay, so now he's going to read on what is in the application of the lawyer that he was talking to, so that to make him understand, okay, why he says it's not actually, a 135 section sub what. All right. So he's trying to make a point to him so that he can understand, or maybe he can go back and look at what they wrote as an application, But anyway, then we're gonna go on, and then we will see where he's going to ask if Bester can talk. Then you will see what is
this application on an attorney and client scale for counsel so employed. Then, in the affidavit itself, you say that you've made out the case for an interdict. Firstly, and I will read it to you. You say, I'm advised that or your client, in order for the application to succeed regarding the final end or interim relief, that I am seeking the application has to meet the following requirements. That I have a clear right that is worthy of protection for a final interdict and a prima facie right, even though open to some doubt, for an interim relief. Now, it's not even clear whether you're asking interim relief or final relief. Then you say that there's a reasonable apprehension of harm, or harm has actually occurred. That the balance of convenience favors the granting of an interim relief. Can you see what I'm talking about? Now, I'm saying to you, Mr. Moyler, and I'm not going to enter into a debate with you about this issue again. I'm saying to you that your prayers, firstly, are civil prayers, and secondly, they stray far beyond the Section 35 rights. Now, you file your replying affidavit, and you act in terms of the rules of this court, and this matter will then be set down. A judge will hear the matter, and the judge will then decide. If you want to argue to the judge that the matter must be postponed, he must make, or she must make a ruling that your client must be there at that stage when you make your arguments, you are welcome to do so. I am not going to entertain an argument now on this half-baked application. Complete the application, complete all the papers, do what you must do in terms of the law, and then you can come back to me. All right? No, you may not speak. You have a legal representative. Yes. You can hear what he has to say. Pardon? You say?
I'm saying that I'm giving an opportunity to write
Yes.
instruction, and I'm
Yes.
asking your lordship to understand, because this is the person that is suffering. So when he sees this engagement, obviously is triggered. So I'm asking your lordship to
No, there's no problem with that, but I will not allow him to speak because you are here to speak on his behalf. Yes.
I think this one actually emanates from the last time. You remember when Pesta was talking, and then maybe they decided that, you know what, we're not going to allow him. He must have a representative. I think also in the past when he was talking there, I think they allowed him, maybe, I don't know, maybe because he didn't have one, I don't know. But I think from there they were like, my guy, you need to get a representative so that you don't talk to us straight. Because you can see that he's like, no, you are not talking, bro. You are not. You've got a representative. Let's take it easy and see.
The issue here, the only issue here, is when the presiding officer of the court to make
Cameraman, why I'm showing
and purport to prejudge the application and not allow the practitioner to comment on
The application will be ventilated in front of another judge at the opportune time, sir. Then you can ventilate all these issues. Mine is to get this matter trial ready. That's my task. If you want to argue all these things in front of the trial judge, you may do so.
What I'm simply saying that, my lord,
Or the judge that will hear the application.
it is in any circumstance, it is unfair for a presiding officer to make ex parte comments prejudging the matter and not give the practitioner to comment on that. And that's why I responded to that. Your Lordship,
To comment on what, sir?
Your Lordship gave me a list of questions. When I was answering the first question, Your Lordship then interjected and not allowed.
Are you going back there now? What is your point, Mr. Moyler? What is your point, please? I fail to understand the point. I've been repeating myself over and over again, and you've also said you'll ventilate this point at the opportune time. Now, this is not yet the opportune time. That is how simple this whole issue is.
Can I make the point that Your Lordship has asked? Your Lordship has asked what is the point, Mr. Moyler? The point that I'm making. When I stood up, Your Lordship gave me a list of questions. Address this, address that, address that. On top of that, the Lordship made comments about our application. And then in addressing those questions, I brought to the court's attention that actually what this court says is opposite to what our paper says.
Okay, guys, I think you can continue watching. You can look at the videos, the live, whatever. Now, listen, guys, I'm not judging anyone, and I'm not saying who's wrong, who's right, or anything like that. All I'm trying to actually show you is that sometimes as a person, you need to, look at the body language of a person. And if maybe you've got another alternative way of maybe explaining that thing, maybe you can use it and say, let me explain it in this way. What I mean is 1, 2, 3, 4, 5. Maybe that alternative might be the only way that maybe the judge will understand, even though he won't maybe agree with you or maybe grant you whatever you are asking or anything like that. But at the end of the day, at least you have tried, instead of you pushing the same thing that is not understanding. And especially if that judge or your owner has actually decided that you are actually wrong and the papers that you brought to me are not complete, you need to go back and you need to complete them, put everything that should be there, and come back to me, And I don't know if the judge was right or anything like that. I'm not going to judge. As a judge, I think I can't judge, okay? So, guys, please let me know what you think in the comments, and also to tell me what you have picked up, okay? Now, he refused Bester to speak. Okay, we all know, I think the last time they allowed him, I think they were like, you know what, we are not going to allow him to do it again. And I think, I repeat again, okay, let me not repeat, right? Because you will say I'm repeating like the lawyer. Yeah. All right, guys, thank you for watching. Please like, subscribe to the channel, share the video. Have a fantastic and a wonderful day.